4 tips for a rock-solid force majeure clause this week on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Solid as a rock, that's what this love is. That would be, I believe, Ashford and Simpson. I'm the old person in the club this week. We're going to be talking about 4 ways to make your force majeure clause rock solid this week. But before we get into it, please, the only thing that I ask in return for this golden information is for you to go to my YouTube channel at Wedding Industry Law, subscribe, hit the notification button, maybe even leave a comment while you're there. That would be fantastic. I am certainly trying to grow my subscriber base, so I would love to see you over in that area of the world. I have lots of content on the YouTube channel, not just this podcast. So when you go over there, you'll be surprised. You'll be happy that you did. And with that, let's actually get into the content. So we are now living in the days of COVID-19. We had a once overlooked stepchild called the force majeure clause that nobody cared about in contracts. Now the force majeure clause is the workhorse. How did we get here? COVID-19. Okay. Now, a force majeure clause, just really quickly, because I've talked about this ad infinitum in multiple episodes, but essentially it's a clause in the contract that is going to prevent the parties from suing one another for breach of contract because the party cannot perform due to some type of calamity or act of nature, hurricanes, tornadoes, alien invasion, these type of things. What a force majeure event is not is something that is within the reasonable control of the parties most of the time. So, for example, if a photographer's hard drive fails and they can't deliver pictures, or if the DJ's, I don't know what those are called, turntables, if the record player does not work, that's not something that's beyond the reasonable control of the parties. That is certainly within the control of that DJ. In fact, it's in the DJ's name. So that's what a force majeure clause is when it applies. The issue that we are having as an industry, because there's so much uncertainty, because as I've mentioned in previous podcasts, force majeure events are typically one-off things: hurricanes, tornadoes, floods, not a worldwide pandemic that causes a catastrophic shutdown of almost every government, every airport in the world. So what we have considered force majeure in the past may or may not apply to the contracts as they were written prior to COVID. So there is a gray area now with, okay, well, what happens with regard to the money that have been paid? Do we postpone? Do we have to cancel? Can we reschedule? All this leaves us in a gray area now. We want to get out of the gray. We want to get back into the black and white. We want 4 ways to make the force majeure clause in the age of COVID-19 strong like bull. All right? Solid as a rock. That's what this love is. Okay, now, 4 ways to make your force majeure clause enforceable and relevant in the age of COVID-19 and perhaps beyond. The first way that we're going to make your force majeure clause applicable to COVID-19 and enforceable is to provide an objective definition to what a force majeure event is. So simply having words that say an act of God or if a pandemic happens is probably not going to be enough, because that leaves the definition of whether or not a force majeure event has occurred open to the interpretation of the parties. So objective definitions are typically things like if the local government or if the jurisdiction in which the event is to take place has mandated X, Y, and Z. So for example, if the local government has said less than 150 people can meet, or there has to be social distancing, or whatever specific thing is relevant to you, putting that wording into the contract is extremely important, because what your client considers a no-go or essentially non-negotiable might not be what you consider non-negotiable, and vice versa. So for example, perhaps the client is not okay with having a socially distant wedding. Maybe you are. Maybe it's okay to have social distance as long as everybody's wearing masks. Maybe it's not. So making sure that these type of specific things, objective things that you and I don't, that no reasonable person would disagree on in terms of what it means, putting that in there, super important. I would say this, while you are trying to define exactly what pandemic situation means, I would argue that it's important to do that from the perspective of both parties. And what I mean by that is, look at it through the eyes of, would I want this event to happen? I feel like sometimes some of my clients that are the vendors are stone cold. Like they're like, whatever, I don't care if we have to be 6 feet apart, 20 feet apart, doesn't matter to me. I said I'd be there, we're going to be there. Now, what happens when the wedding party is not allowed because of whatever jurisdiction they're coming from, hop on a plane and literally travel into that jurisdiction? What if it's impossible for them to do that? So these are the type of things that you want to look at. Make sure that that is defined as objectively as possible and open to as little interpretation as possible. That's your first way to make your force majeure clause stronger, defining what it means to be a force majeure event for COVID-19. Now, next thing to make your force majeure clause strong like bull, obligate the parties to reschedule. So if there is a force majeure event, you need to obligate the parties to work together. The reason why that's advantageous, I don't have to tell you, because if you're able to salvage contract value from that event, then you want to do it. Why do you want to cancel? No, we want to postpone and reschedule, because that way money keeps flowing in. The cash that you have doesn't have to go back to the client, and you can continue to operate. So rescheduling should be obligated. A couple things to say about that. Number one is you want to make sure that the parties are obligated to work in good faith. Now, what I mean by that is you would put in things such as, do you want the client to propose 3 or 4 dates, 5 or 6 dates? Do you want to put that on yourself? In other words, the parties will provide each other 3 or 4 dates that are comparable to the one that was canceled. So in other words, if the event was scheduled for a Friday, then you would give as a reschedule 4 or 5 Fridays in the future as a way to reschedule, as opposed to Tuesday morning or February 30th, right? So working in good faith to provide different dates to reschedule. Now, with that being said, it's also important within that subset of obligating to reschedule is to make sure that you're operating within a time frame. So what I mean by that is, how long do you give each other to reschedule? Now, prior to the age of COVID, my anecdotal, unscientific, non-538 science said that between 9 months to a year was pretty typical. So the parties would have 9 to 12 months to reschedule. Now that I think that it's okay to be a little bit longer. I think the clients understand that, and people are not going to stop getting married. Well, as far as I know. So if you want to go beyond that, that's probably okay too. I would say you can't go extreme. You don't want to go 6 years. You also don't want to go the extreme the other way. You can't say, all right, well, let's just reschedule in 6 days. So obligating reschedule, making sure that the parties operate in good faith, and then putting a time frame to it. That was your number 2 way to make your force majeure event or force majeure clause stronger. Now, third, dictate what happens to the money. What happens to money if a force majeure event occurs? So 2 things with this. One, hopefully you've got it to where, because you're obligating the client to reschedule, that you're just going to hang on to whatever money you've already been paid, and you're just going to move forward and reestablish the dates in which further payment would be due. That's one way to do it. If the parties don't want to reschedule, or there's for some reason the client and you are canceling the event altogether, you need to make sure the force majeure clause handles when and how much of the money that you already have goes back, if at all. And I want to reiterate this. Most of the time, again, I haven't read your contract, but most of the time, your non-refundable deposit is not applicable in force majeure situations. That is an altogether different beast in most jurisdictions. So you will need to deal with money in the event of a force majeure event in a way separate from your non-refundable deposit. So I want that to be said. The second thing about dealing with money is that you want to educate the client on any type of instance in which there will be an upcharge. So for example, if in the course of rescheduling the event, if the event went from April to November, that might affect how much flowers cost or the price of a lobster. I don't know. I don't eat lobsters. I only eat Taco Bell. So these things need to be told to the client in the contract. So for example, client agrees to be susceptible or incur, whatever the case is, reasonable fees for postponing or rescheduling the event due to force majeure. But I would go even further to say such as, and then XYZ, depending on whatever your industry is. And you don't have to do that if you don't want to. I'm just saying that in the instance that your contract is variable by season, then yes, educate the client on what upcharges there will be if it is rescheduled. That's number 3, dictate what happens to the money. Number 4, lucky number 4, batting cleanup. Your force majeure clause should emphasize and reiterate that the client assumes the risk of cancellation due to force majeure event. So in other words, if the parties can't move forward and reschedule, if the client simply does not want to, the client assumes whatever comes to them. That means that you are ready, willing, and able to go and reschedule. If they're not, then sorry, Charlie. And this is why it's important to dictate what happens to the money, but that would occur. The other thing is this: have the client, wherever possible, be obligated to get insurance or make other arrangements in case a COVID event happens or in case the force majeure event happens. Because I want the trial judge that reads your contract later on to look at that force majeure clause and go, wow, look at this. You agreed that you're assuming the risk of a force majeure event. You agreed that you would make provisions or arrangements so that you could tolerate if the event was canceled. You passed that risk from the vendor to yourself. Okay, I'm finding for the vendor. That's the kind of action that I want to have happen based on this number 4, having the client assume the risk of the force majeure event. But again, all these things are dependent on what jurisdiction that you live in. These are just general guidelines that I think that you should look out for, that I think that it would be recommended that you check out, take to your local attorney. The 4 things to make your force majeure clause strong, like bull, in the age of COVID-19. Objective definition of what it means to have a force majeure event with a pandemic. Obligating the parties to reschedule within a time frame. Dictating what happens to the money if you cannot reschedule or if there's some type of upcharge. And finally, having the client assume the risk if the event will not go forward at all. That is going to do it for this episode. I kept this episode super high and tight. My wife keeps telling me that I am dragging these things on for far too long. The statistics definitely show that if you are listening to this, you're probably one of at least 6 people, because I'm not counting my mom in this. So trying to make this a little bit more juicy in terms of content, not dragging on, getting right to the heart of what matters. And what mattered this week was force majeure. So again, if you are enjoying the content of these episodes, then please, by all means, like and subscribe wherever you get it. Go to YouTube, please subscribe, hit the notification button. Again, you can, if you subscribe, you don't have to watch, but you do have to subscribe. I would love it. Be your best friend. Check me out on Instagram at Wedding Lawyer. And with that, folks, thank you so much for the 12 people, the 6 people, the 5 people, not including my mother, that listened. We'll see you next week.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.